So the reason I got a little interested in this year was because Rebecca actually was defending or saying that you could not have an attorney's lien in a case against Mike and Gary. So we started arguing about it. So I said, well, let me look into it. So what I did was I just went to Tom's work that he did like 5 years ago and copied it, just kidding, but took it and then went to what Gary Schlesinger always says, which is, I'm going to summarize in a minute, and then looked at what Rebecca said, and I think we're okay. So this is the deal. Our rules of professional conduct essentially say that you can have a lien and you can secure it, your fees and expenses. So you go to the ABA and the rules of professional conduct, and this is what they say. But then you have these cases. So there was a case in 2005, and it had to do with the ARDC coming after a guy named Levy, and they basically said to him, you have to send out a bill in order to create some kind of bill and to get a lien for it, and you didn't do that. And he was defending because the client came in and said, look, I want to get my file. And what was interesting about that was it was like 5 years later, and he then sent out the bill. So they cited twin sewer, and that's important because that says that the statutory lien only attaches to proceeds recovered by an attorney in the underlying litigation. They also cite Sanders in this ARDC case, and that says also allows for a lien. In that particular case, the attorney was afraid, he was fearing a lien. They're like, that's not enough. You actually have to bill, you have to incur the time and the expense. So the case, the reason I mentioned Gary is he always says, Johnson v. Cherry, Johnson v. Cherry. So that's a 2005 Seventh Circuit case. And in that case, the appellate court does acknowledge the existence of a common law lien and stated that it's not unethical to turn over the file, okay? So in that case, the trial court failed to determine was the attorney owed monies, was the retaining lien valid, what is the client's need to access the file, and then you got to balance this need against the attorney's right to compensation. Now this is where Rebecca tripped me up a little bit and made me nervous because she just kind of cited a very small portion of a case, and that was the McGill case. It's from 1972, and it actually says in that case these kind of attorney lien claims are not applicable in divorce cases. So I read this and I'm like, oh my God, how could we all have missed this for so long? Well, you keep reading and the gist is in that case that the guy was defending a motion to compel production of his file, and we didn't have 508. So they're like, what are you doing here? Get out, you need to file a petition. We had no way to file a petition for fees in order to get our fees. So you don't have to really worry about that because it was pre-508. So if someone cites that, that's where we're going. And it just scared me. The other case that's important is Lucky Gold Star. That's a 1986 case. And that just kind of tells you that this is what the court should look at, the financial situation of a client. The sophistication of the client in dealing with lawyers, whether the fee is reasonable, whether the client understood and agreed to pay the amount that was owing. There's some other things in there of that nature, but in that case, this was kind of interesting. It was a large company, and they clearly owed the money, and rather than just say, okay, pay the bill and get your file, they said, post security, and then give the file over. So it was like the court's way of basically saying, how can I make both parties happy? And they each got what they wanted. Now here's the kicker, and Mike and Gary talk about this as well. I attached the statement of client rights to my outline and underline the part that is a little problematic for us. So we have to put this on our retainer agreement. And if you read it, it basically says, I'm going to read it out loud. I'm not sure why it's not raised. In the event that counsel withdraws from representation or is discharged by the client, the counsel will turn over upon written request to the substituting counsel, or if no substitutions, to the client, all original documents and exhibits together with complete copies of all pleadings and discovery within 30 days of the counsel's withdrawal or discharge. Now, personally, I would take the position that I already send all that out throughout the time that I'm in the case and I have record of it. I know just by experience that that sometimes isn't the case with everyone. I don't mean you all, I just mean in general in cases. So I'm just raising it so that you're aware of it and you know if someone else raises that to you when you're trying to defend your lien, to be ready for that argument. But essentially what I'm saying is I think we're all good as long as you bill, incur the cost, and are sending out your correspondence, discovery orders, and pleadings on a regular basis. Okie dokie? Thanks.
Thank you.